Welcome back to another exciting episode of our podcast. I am Hari, and joining me today, as always, is the brilliant Kimmy. We have an incredible legal and cultural journey ahead of us.
Hello, everyone. Today we are diving deep into a fascinating intersection of constitutional law, high school sports, and religious freedom. We are unpacking the notable 1982 case, Menora versus Illinois High School Association.
It is a phenomenal story. Let us travel back to February 1981. It was tournament time for Illinois high school men's basketball, and two rival Orthodox Jewish schools were gearing up for the competition, Ida Crown Jewish Academy and Yeshiva High School.
Yeshiva was making its tournament debut after beating Ida Crown for the very first time. However, the tournament was governed by the Illinois High School Association, or IHSA, which had a strict rule prohibiting headgear on the court for safety reasons.
This is where the conflict ignites. The students wore kippot in accordance with their religious beliefs. In fact, between the two schools, they had played 1,300 basketball games in the IHSA wearing kippot fastened with bobby pins. When Ida Crown was once told to remove them, they actually forfeited the game.
1,300 games without a single reported injury. But as the tournament approached, the IHSA dug its heels in. They reached out to the National Federation of State High School Associations, who backed their rule. The IHSA claimed a kippah could fall off during a game and cause a player to slip.
The students tried to compromise, arguing that bobby-pinned kippot were analogous to the allowed soft metal barrettes. Even their first opponent, top-seeded Harvard High School, had no issue with the kippot, but the IHSA refused to budge.
Unwilling to compromise their faith, the students, their parents, and the schools sued. Led by Moshe Menora, parent of a yeshiva player, they claimed their First Amendment right to the free exercise of religion was violated.
The legal background here is absolutely fascinating. Historically, Jewish people in America relied much more heavily on the Establishment Clause to blend in, avoiding being othered, and to actively ensure those broader American customs did not become exclusively Christian in nature.
Exactly. But by the 1960s, Orthodox Jews began wearing the kippah openly in public, proudly combining their Jewish and American identities. So they pivoted to the Free Exercise Clause. The lawsuit relied on the Sherbert test from 1963.
The Sherbert test required the government to have a compelling interest to restrict religious freedom. So, on the day Yeshiva was scheduled to play, they went to the district court for the Northern District of Illinois.
Here is a fun, lesser-known fact. Judge Milton Shadur held a hearing and granted a temporary restraining order at 4:30 p.m., allowing the students to play in their game just 4 hours later with their kippot.
The judge promised a follow-up hearing, but tragically for our underdog narrative, both teams got crushed in the first round. Yeshiva was flattened 99-54, and Ida Crown lost the next day 79-51.
Ouch. Despite the exit, the legal battle escalated. The IHSA asked Judge Shadur to recuse himself due to his Judaism and ties to the American Jewish Congress. Shadur firmly refused.
In November 1981, Judge Shadur ruled for the students. Applying the Sherbert test, he found the IHSA's safety concerns were totally speculative. Without evidence of kippot causing injuries, there was no compelling state interest to force the kids to choose between religion and basketball.
Naturally, the IHSA appealed. Enter Judge Richard Posner at the Seventh Circuit Court of Appeals. Instead of the Sherbert test, Posner used the false conflict approach, originally advocated by Brainerd Curry.
Posner argued that by rigorously defining both interests, there might be no actual conflict. He deemed the safety interest reasonable, but reduced the students' interest to merely having a head covering, noting the kippah itself was custom, not strict halakha.
Posner ruled the students could satisfy both interests by designing a safer head covering. He literally put the burden on the plaintiffs, stating the court did so because they know so much about Jewish law.
Judge Richard Dixon Cudahy wrote a scathing solo dissent. He argued the IHSA imposed a significant burden on the students' religion, and the Sherbert test should apply, especially since the IHSA refused all compromises.
Legal scholars later tore into Posner's approach. Writers like Judith Mills in the Wisconsin Law Review and Dale E. Carpenter pointed out Posner incorrectly assessed the harm. They said he valued basketball participation over true religious freedom. Kurt Feuerschwenger also argued Posner failed to avoid Sherbert's complexity and made it far too easy for the state to justify its regulations without proving their actual, real-world reach.
Yet, Posner's ruling forced a stalemate. The IHSA couldn't maintain a total ban, and the schools wanted to avoid wearing absurd headwear, so the Jewish schools hired a physicist.
They did. Testing different materials and fasteners, the physicist discovered that contour clips kept kippot in place far more effectively than bobby pins. It was a practical, familiar solution.
The IHSA agreed to this compromise. In June 1983, Judge Shador accepted the settlement, bringing the grueling legal battle to a close.
It was a massive cultural victory, firmly establishing the kippah as a public symbol of Orthodox identity. Zev Elif's book shares a great anecdote. In fall 1983, a yeshiva player dropped his kippah and kicked it under the bleachers to save time. His coach stopped practice, yelling, "If you only knew the trouble we went through to make sure you could play basketball with your head covered."
That perfectly encapsulates the legacy. While the Supreme Court weakened the Sherbert test in 1990 with Employment Division versus Smith, Menora remains a highly notable case. As of 2013, it was allegedly the only federal appellate case regarding religious headwear in schools, though some sources point out that a 1990 Third Circuit decision involving the Philadelphia School District also addressed the issue, and the IHSA still retains a religious exemption today.
It is an incredible intersection of sports, faith, and the law. Thank you all for tuning in. Goodbye, everyone, and stay curious.
While you might think this episode is based on the Wikipedia article Menora versus Illinois High School Association, the factual relationship is actually inverted. The Wikipedia article lists a 2022 episode of the Yeshiva Show podcast as a source. This podcast was crafted using artificial intelligence.